Hello. Sandeep వినపడుతుందా?
Hello.
Yeah, I can hear you.
Hear me?
వినిపిస్తుంది.
So revised deck, okay, content same kada. You start presenting. Rendo window lo goals ఉన్నాయి కదా, అది ఓపెన్ చేసి పెట్టండి. ఇఫ్ నెసెసరీ ఐ స్విచ్ టు దట్, లేదా అంటే ఈ డెక్ ని ఎక్స్ప్లెయిన్ చేయడానికి ట్రై చేస్తాను. This is for all people who may not have explored litigation like you also.
Okay. You can see, right?
Yeah, looks good. Maybe join. Maybe 5 minutes wait చేసి రికార్డింగ్ స్టార్ట్ చేయకూడదా?
Recording button.
Basically the idea of this session is to help you understand how to think and not what to think. So I cannot tell you on what topic, on what issue one has to file a PIL. No, even before we go to that, what do you mean by PIL? So basically PIL is an acronym for public interest litigation. It is a kind of writ petition, basically, that one files either in High Court of a state or the Supreme Court of India. Now, what is the purpose? Why we go about, how we go about is what I want to discuss in the next 8 slides. And due credit has to be given. The organization of this session is done by Priya, and I am trying to help you share my understanding how to go about it in this session. Now, let's move to point slide 2. So to begin with, I would like to talk about what is the life cycle of a public interest litigation in the general sense, how one has to begin thinking about it, and what is the way forward for an advocate. Basically, this is not for general citizen. They may not understand the technical legalities. So this is for people who are a little familiar with the law and what is meant by a writ. Okay, the fundamental principles of a PIL. There are many principles, but one which is very core to that principle or the remedy of public interest litigation is ubigus ab remedium. So basically, it's a Latin maxim, Latin saying, which says if there is a right, there should be a remedy. Okay, so this fundamental principle, for example, I have a right, I need a mechanism to enforce that right. Right? I will not be taking any examples at this point in time. I want to keep abstract. So wherever there is a right, the principle says there should be a remedy to realize that right. And this fundamental principle is enshrined in the Constitution of India under Article 21 of Part 3. So Article 21 protects the right of life and personal liberty. So this particular right is the realization of this principle, a Latin maxim. Okay, let's move on. Now, this is exactly what it says. Means where there is a wrong, basically, there is a remedy. But then if you turn it around and make it reverse. For example, there is no legal remedy when there is no legal wrong. If nothing is, there is no crime, there is no issue, there is no wrong happening, you cannot go for a remedy. This fundamental principle is what we might have heard in the recent times. There are so many public interest litigation cases dismissed by the Honorable High Court and Supreme Courts with the costs, saying that those cases are publicity interest litigation. So what does that mean? If there is nothing wrong. For example, I don't like a particular movie. I want it to be banned. I don't want it to be screened in theaters. So I go and file a public interest litigation in High Court, saying that this particular movie should not be telecasted either on theaters or in TVs. So now court will pursue that case and see if there is any wrong in that. Something wrong is happening or not. If there is no wrong happening, that means the person has no right to claim a remedy when there is none. Okay. So the very crucial part of it is there should be a wrong that is happening. And that wrong, we should convince the Honorable Court that this is a wrong. How to convince? We have different ways of convincing the Honorable Court. Okay. Priya, next slide. Next. Yeah. I just said that these remedies, the writs can be invoked in the Honorable Court of High Court of any state or in Supreme Court. So this pie and the next pie, which is the last pie, talk about the articles of Constitution of India using which we can invoke the right of writ. Basically, I have some loss happening, something wrong is happening with me or my property or the people I have interest in. So I want this court to give me a relief to that, a remedy to that. So Article 226 is what we have in Constitution of India to invoke writ jurisdiction of high courts. And the next slide, next bit, is Article 32, basically. So if you can see, Article 32 is again part of Part 3 of Constitution, which is very, very important, which talks about fundamental rights of all citizens and people. Some rights are not just for citizens of India, it is for all people, any person. So these two articles are what one has to use to invoke the writ jurisdiction of high courts in a state under Article 226. And if our attempt fails at the high court level, you have a right to appeal it before the Supreme Court under Article 32. Okay, so this is a fundamental thing. If there is any wrong happening to me, to my property, to the people I have interest in, I can go to High Court. If right is there and someone is not giving me the other side, basically commission and omission. A right is there, someone is not giving me. For example, I have a right to clean water, but there is a sewage overflowing right in front of my home. Clean water and clean air is my right, and municipalities are not providing me that right. So I can go to High Court saying that this particular municipal corporation is violating my right. Okay, so that is how we have to approach it. We should find the starting point of appeal is we should find a problem. It can be ours or it can be a general. For example, a few months back, there is a gas leakage in Vizag city. Many people suffered from that, and a couple of people, I think, died. So there is not one person suffering because of that gas leakage, but many people suffered. So sitting at Vijayawada or sitting at some other place in India, I can file a writ petition in Andhra Pradesh High Court asking for relief for those people who suffer. Okay, so this is the fundamental principle of public interest litigation. I need not be the victim. I can be a total stranger to the issue, but still I can invoke the writ jurisdiction and say I have it need not be myself. These particular people have a right and they are their rights are being violated. Okay, next. Yeah, the next couple of bullet points, I will talk about what kind of thinking, the steps necessary for us to think. Basically, the first one we just now discussed. We need to have a wrong happening. Some rights violation is happening. Someone has faced an injury or a damage. Something negative should be happening. That negative is what we have to take to the honorable courts and say this is wrong because of this rule, this laws, and these people are need to be compensated appropriately. So that is what it is. The next, right? And especially Article 21 should be applicable, right? Article 21 talks about right to life and personal liberty. We have to make one contention, one argument before the Honorable High Court or Supreme Court that a person or group of persons' right to life is being affected or right to personal liberty. So these two rights are very wide and vast, as you will see in the next slides. Under Article 21, there are like 50 to 60 rights available. Right, right to life, right to death, right to, there are so many things, clean air, clean water, right? And then once we find that there is a issue happening around you, and we know it affects someone's personal liberty or life, then we have to see under what laws this particular right is protected, which is being violated by some person or organization. So we have to research. If it is a roadways that is getting affected, there will be a law administering the roads, laying of roads. If it is a municipal sewage issue, there will be authority, and that authority will be functioning under the provisions of a particular law. For example, if there is a motor accident happening and nobody cares the victim, so this motor vehicles and the accidents around it is covered by Motor Vehicles Act, MV Act. So we as lawyers or someone interested in law, we should research the law, what is the applicable law and what exact provisions in that law is being violated. So we are basically narrowing down, right? Next. Right. So now, once we find a particular law and the exact section in that law which is being violated by some authority or a person, then first of all, we should send a representation to that authority. For example, the other day I went to a post office and they are not accepting fees for stamps, etc. on what is that, UPI, right? They are asking for cash or coins. So I asked why, because of COVID season, why are you accepting asking for money? Why don't you accept the fees as digital money? So they did not say, no, we don't have any instructions like. So then I sent a representation to post office, postal department, and asked them why, which post office are accepting digital payments, which are not accepting. So very innocent looking questions. So I sent that representation. In the end, I asked, can you please start accepting digital payments? People who can make digital payments, they will make digital payments. Who do not have mobile phones, who do not have UPI, etc., they will make the payment on cash. So I sent that representation. So one should send the representation. And then if the authorities are unresponsive, then go ahead and invoke the right, invoke the jurisdiction of the Honorable High Court in that state. Okay. In that you will say, Your Honor, I sent representation to the post office, railway department, a municipal corporation. They did not respond within a time of 2 weeks or 3 weeks. There is no time limit actually. So you can send a representation and after 1 week, you can go to High Court. No problem with that, right? And then you ask the High Court, pass a direction to the post department, railways, or any other department, roadways, etc., and ask them to respond to your representation. First, prayer. Second thing is, if they are not responding to your representation, you can ask the High Court to pass directions on action. For example, implement digital payments in post offices. See, this is totally, people may not see the value in it. You don't have to worry about the value. You just have to see if something is wrong is happening, and then it has to happen. That is the right thing to do. You go ahead and send a representation and then invoke the writ jurisdiction of Honorable High Court. You have to file a writ petition in the High Court and get it listed, and then go before the Honorable Court and make your submissions, saying that digital payments are being encouraged by the entire central government as well as state government, but post office, railway stations, and these are very big organizations who are directly connecting with the public. Still, they are not implementing digital payments, right? So, and that may not convince the courts. How is it affecting the point number 2, Article 21? So, Sandeep, which right of your is getting violated? I will say my life. For example, if I'm making a payment by cash, I am putting myself at risk of contracting COVID virus or any of the variants of the COVID virus. So, by forcing me to make a cash payment or by way of notes and coins, Postal Department has put my right to life in danger. Correct? So, when you argue something in the court, you have to connect it to the laws of the land and say law is on my side. But the public authority, the government is on the wrong side. I am on the right side. Hence, the Honorable Court has to side with me. They have to support me. Right? That is how you go about arguing a public interest litigation before a high court, very high level. I'm not talking in any detail. I'm talking about a high level. And then obviously there is a higher appellate court, Supreme Court of India. If your attempt at high court fails for whatever reasons, maybe we did not write the drafting properly, we did not submit to the court properly, one way or the other, we could not convince the honorable courts. So we can go to Honorable Supreme Court under Article 32. Okay. There is certain reading material from ipleaders.com. You can read that for the reading available. Next slide, please. Right, like I said, you have to file a representation to the authorities. Who are the authorities? In my case, I sent a representation to Postal Department, Department of Posts, and asked them some questions, like 4 or 5 questions I asked. Which post offices are made digital post offices? Which post offices are accepting digital payments? Which post offices have a CCTV camera set up in them? So something like that. Very innocent looking, straightforward questions. Your questions should be in a way that the authorities will be able to give back response easily. Okay. And I used a tool called as RTI. RTI is short for Right to Information Act 2005. So under this act, any citizen or person within India can file an application to a public authority and ask for certain information. So if you go through this, this act, it is around 10-15 pages, around 30 to 40 sections, very small act. You will know how effectively you can get the data necessary for it. I did not shout at the post office people. They are just employees. They don't know anything. I cannot shout or get into an argument with the employees. They are just staff. I have to hit the root of the problem, which is the person or the organization making decisions. So you have to hit the decision makers, not the staff. So I used RTI. Next. Right? Yeah. So if you have to file an application, you should know who should receive it. Right? Under RTI Act, there is an entity called as Public Information Office or Officer. In each government department or government instrumentality, there should be an officer called as Public Information Officer. This particular officer should receive our applications. That is the to address we have to send our RTI application. Okay. And that particular Public Information Officer will have 30 days time to reply to my RTA application. Each RTA application we have to send some processing fees. Generally, it is 10 rupees per application. You can add any number of questions, but it is advisable to put at least 5 questions or 10 questions. That is reasonably sufficient application. And you have to file the RTI fees also. Next. Yeah. And for the many years in the past, RTI applications can be filed online also for all central government agencies like Postal Department, Railways, BSNL. So there are so many organizations, central government entities. So you can file RTI application through online, right? If such a facility is available for the PIO to which you want to send the RTI application, use that. For all the rest of the departments where there is no online facility, obviously we will use offline facility. When you are sending offline facility, send only through register post with acknowledgement due card, because the authority will have to seal and stamp, sign the acknowledgement card, and that acknowledgement card comes back to your home address. So that is a proof that your RT application has been received by the intended recipient. Next. Yeah. If the RTI fees, for example, you can send an RTI application to High Court also. There is a public information officer in High Courts also. And if you send an RTI attaching 10 rupees fees, they will return it back because they have decided on their own that my RTI fees will be 25 rupees. So before sending an RTI, you have to find who is the right public information officer, where your RTI should go, if there is an online facility or not, if RTI fees has to be paid, what is the fees? Okay, and where can I find this RTI fees? On their, most probably on their website. Generally, there will be RTA section for BSNL, India Post, Indian Rails, and where you will find a fees section. So you will know if they have different fees other than 10 rupees. Next. Yeah, this is what I said just now. Don't send by courier. Always use register post. Hardly it takes 22 rupees, 25 rupees per register post, or 30 rupees maximum. So use the register post only to ask for information. Here, one important information. Next, please. Please read this. So be very careful. I don't want to threaten you. This is only one of the many persons who got killed just because they asked some information from a public information authority. Here, there are a lot of things. One thing is there is a religion angle to this, but the other thing is he asked for certain information which he may want to use in a high court. So he was gathering information by filing RT application. So my point is, but there will be some risk associated when you are going for public interest litigation. Public may benefit, but only problem is someone else will be impacted, right? Someone else's livelihood on which they might be living, that will be impacted because of your public interest litigation application or petition. So be very careful with whom you interact, to whom you communicate your ideas and plans, and do this kind of activities very, very, not secretly, but then it should look innocent. Okay, next please. Now, what is Article 21 and what are the rights available under Article 21? Article 21 is very simple, straightforward line sentence. No person, it did not say no citizen, it said no person. That means non-citizens also are covered. No person shall be deprived of his life or personal liberty, except according to procedure established by law. If a law is established to take away my life, then I can be deprived of my life. For example, I committed a gang rape or whatever, a robbery. I killed many people. So I am convicted with a capital punishment, hang until death. So in IPC, there is a section given. What are the punishments? I think 52 or section 52 IPC. So in that it is given capital punishment. So capital punishment is defined as is a procedure established by law. So using the IPC section, the government can take my life. Similarly, I am causing someone some distress, nuisance, noise, some damage I am causing to my neighbor, right? So the municipal authorities or the police have authority to restrict my personal liberty because I am causing inconvenience and disturbance to my neighbors. So, except according to procedure established by law, no person shall be deprived of his life or personal liberty. Now, let us look at the different rights. Okay, next. These are only few taken from a, I think, Unacademy video, training video. There are many more. Okay, life, right to live with human dignity, right to decent environment. I don't know what is that decent. Right to livelihood. That means nobody can stop me in doing my job. If I have to go abroad and do my job because I have an on-site opportunity, nobody can stop me. But people can stop me according to procedure established by law. For example, I committed a crime in India. Now I want to escape to some other country. I can't do that. Right? So right to privacy. This is very famous judgment. Is there 9 judges have given this. Aadhaar card judgment, Justice Puttaswamy judge. And right to shelter. Nobody should be left to streets. Right to health, right to free education, legal aid. I am unable to engage an advocate by paying a huge fees to the advocate. So government will provide an advocate to me. Government will pay the fees to the advocate. So that is right to free legal aid. So there are so many other rights. So now, if you, all 3 of you, if you see any of these rights getting violated, or you are made aware, or you come to know someone is getting someone's right is getting violated, so now you have a cause that you can take to High Court. Okay, right to information. If someone is denying you information, even then that is a violation of your fundamental rights. Article 21 precisely. So you can file a petition to High Court asking for rectification of this violation. Yes. So, like I said long back in the group, we are surrounded by violations. It is just that someone should take it to the court. It is right outside High Court. Someone has to take into the court. Right? Speedy trial, handcuffing, yeah, delayed execution, right to travel abroad, custodial harassment, emergency medical aid. Right, so to implement the right to emergency medical aid, what central government has done is, earlier, if a road accident happens on a highway, nobody used to stop and help the people who are suffering because of the accident. Now, central government has made changes to the rules, and they are encouraging people to help the accident victims. They are giving incentives, basically, more like appreciations. So thereby, government is trying to ensure there is a medical aid. And if some medical professional or a hospital denies or refuses to give medical aid as a first aid, they will be subjected to punishment under 161B. 166, I think 1B. So they will be punished for 3 years, the doctors and the medical professionals, if they refuse to give emergency medical aid to accident victims. So similarly, I mean, this is just a very brief listing. There are many more rights, and this is just one article. There are many other articles in the Constitution which uphold your fundamental rights. If any of those fundamental rights is getting violated, and you can see it is protected under one of the articles of Constitution or one of the laws of the land, you can go to High Court. Okay, next please. And I have given a couple of just a moment. Go back 1 second. Yeah. in this, I have given all the laws from my website covering Article 21. Some of these rights are covered in those judgments. If you want, you can search for different rights. For example, right to hearing, right against public hanging. So these rights, if you can search online, you will find the judgments also. You can go through them. Yeah. Next. Okay. Now, I want to talk about Article 32 first before going to Article 226, because Article 226 refers Article 32. So let us understand Article 32 first. So Article 32 is remedies for enforcement of rights, obviously for, fundamental rights, conferred by this part. So they are this is actually part of Part 3 of Constitution. So they are referring it as this part. Right now, for the first clause. So in Constitution, you will talk about articles, clauses, and subclauses. So these are the words we use. So 32 is article number, 1, 2, 3, 4 are clauses. If there are any entities below 1, 2, 3, 4, those will be called as subclasses. Okay. Now Article 32 says in remedies for reinforcement of rights. So there should be a right which is getting violated, and this article allows to remedy that situation, violation of fundamental rights. The right to move the Supreme Court by appropriate proceedings for the enforcement of rights conferred by this part is guaranteed. This is such a fundamental thing. We might think that, okay, AP High Court is like 30 kilometers. I can walk up to the 30 kilometers or travel by a vehicle and go into the court. No, that may not be possible if you are restricted to approach a court, that Supreme Court basically. Even that is a fundamental right violation. Your right to approach a court is also guaranteed. No one can stop you from approaching Supreme Court. I'll tell you an example. There are so many advocates and non-advocates who file publicity interest litigation in Supreme Court directly, bypassing Delhi High Court. They'll directly file a public interest litigation, which is basically for publicity. Okay. Even those people are only fined by the Supreme Court, but that they are not discouraged. They are given warning. Don't file this kind of publicity litigation. I'll tell you one example. You might know actress Juhi Chawla. Okay, I don't know about her technical educational background, but she filed a litigation in, I think, Delhi High Court, asking this 5G technology, 5G wireless technology is detrimental to birds and young children and sick people, old people. So 5G technology should not be allowed in the country. That is the petition. So Supreme Court dismissed the, so I think High Court dismissed the petition with 5 lakhs as fine. This happened many months back. Till dates, Juhi Chawla has not paid that 5 lakhs. Okay, this is how situations are there in India. It is very difficult to wade through this jungle kind of atmosphere in India. Now, point number 2. Okay, you approached Supreme Court. What can you ask Supreme Court for? Supreme Court shall have the power to issue directions or orders or writs, including. So that means the next following things are only examples. Other than these remedies, Supreme Court can pass any direction. Okay, and anything under the sun. Now, what are the writs? Examples given: habeas corpus, okay, mandamus, prohibition, quo warranto, and certiorari. These are 5 writs, types of writs, which Supreme Court can pass, whichever may be appropriate for the enforcement of any of the rights conferred by this part. So this Part 3 of Constitution provides many fundamental rights. If any of those rights, one or many rights, are getting violated, to rectify the situation, Supreme Court can pass these writs. Okay, so habeas corpus, we might have heard, habeas corpus is bring the body. For example, someone is taken away by police illegally. So you go to the Honorable High Court or Supreme Court and ask for this petition. So High Court will pass or Supreme Court will pass a direction to the concerned police, bring that person to the court. Okay, so that is habeas corpus. Mandamus is passing with passing a direction. Do this. You have to do this. Prohibition is the reverse of it. Don't do this. For example, demolish a building is mandamus. Don't demolish a building is prohibition. Okay, just taking an example. Quo warranto is with what authority have you done this? For example, my boss cannot fire me. He cannot terminate my services, but he still passed an order saying that I'm terminating you from the services. I go to the Supreme Court and say, I file a writ petition under quo warranto. So now my boss has to come to the court and explain under what authority he has terminated me. If he doesn't have authority, his termination is void, ineffective, right? So certiorari, I don't remember what is certiorari. I mean, that is not a point here. We have different kinds of rights that Supreme Court can enforce. Now, point number 3. This is very important. I'll come back to this a little later. Without prejudice to the powers conferred on the Supreme Court by clauses 1 and 2. That is, Sandeep's right to move Supreme Court, Sandeep's rights to ask for writs is protected anyway, right? Without creating any damage or issue to these first 1 and 2 clauses, Parliament may, by law means Parliament can pass an act. They have to pass a law. And by passing a law, what can the Parliament do? They can empower any other court. Obviously, any other means other than Supreme Court. Right? Any other court to do what? To exercise within local limits of jurisdiction all or any powers exercisable by Supreme Court under clause 2. So, Parliament can pass a law, right, and empower any court in India to implement the clause number 2, that is passing of writs. That power can be given to any court. So there is a public interest litigation that we can file for this also. I'll talk about it later. The last clause is right guaranteed by this article shall not be suspended except as otherwise provided for by this constitution. So under the Constitution of India, there are 3 types of emergencies in the country, in India. So if such kind of emergencies are proclaimed, announced by the President of India, even then this particular right to approach a court is not suspended. Okay, this is Article 32. So this, to quote B.R. Ambedkar, he said this is his favorite article in the entire Constitution, because for all other articles, all other laws to take effect, or if you have difficulty with any of the articles or laws of India, you can approach the Supreme Court under this article. So this is the path to go to Supreme Court. That is why he liked this article. Next, please. Now comes Article 226. So this is the power of High Court basically to issue certain rights. So that is the reason, if you see, notwithstanding anything in Article 32, every High Court shall have power throughout the territories in relation to which it exercises jurisdiction. Basically, a state High Court will have jurisdiction, like power to enforce its orders within the state. Right. So what can the High Court do? Shall have power to issue to any person or authority. Okay. It can issue to a person or an authority, include any government also. Within those territories, orders or writs. So High Court can pass orders and writs and directions to any person or authority, including these 5 writs in the nature of habeas corpus, mandamus, prohibition, pure and certiorari. Either one of them or any combination, basically. Why? To achieve what goal? For the enforcement of any of the rights conferred by Part 3. And the crucial 5 words are at the end. And for any other purpose. So by adding these last 5 words, High Courts have more power than Supreme Court in this particular subject matter. Supreme Court can only pass directions to protect the fundamental rights only. But 226, Article 226, under Article 226, High Courts have power to issue writs for any other purpose, not just for enforcement of rights. Okay, next please. Next. Next. Okay. So basically, these are other sections. I'm not going to touch upon them. Next, please. Now, till now, I have been talking about Constitution and a couple of articles from the Constitution. Now, we have a similar, not exactly same, similar remedy under CRPC itself, right? I'm not going to bore you with all this information. If you quickly move to the next bullet points, right? See this. Whenever a district magistrate or a subdivisional magistrate or any other executive magistrate, okay, specially empowered in this behalf by the state government on receiving the report of a police officer or other information and on taking such evidence. So a district magistrate, when receiving a report or a complaint, report is FIR from a police officer or other information. If a public informs the district magistrate, considers that any unlawful obstruction or nuisance should be removed from any public place or from any way, river or channel, which is or may be lawfully used by public. For example, public are using a particular road. All of a sudden, a statue, shows up on the road, or a Mazar shows up tomorrow morning. Mazar is a samadhi basically. All of a sudden. Or a small, Mary Mata statue comes up on the road. So that is lawfully used by public. Now this statue or something has come up, obstruction has come up. So district magistrate has a power to remove that obstruction because it is being lawfully used by the public and it causes inconvenience and nuisance to the public. Likewise, there are quite a few things given under section 133 of CRPC. Okay, you can see that the construction of any building or disposal of any substance as is likely to occasion conflict or explosion should be prevented or stopped. That any building, tent or structure or any tree is in such a condition that is likely to fall and thereby cause injury to persons living or carrying on business. So that is one thing. That any tank, well or excavation adjacent to any way, public place should be fenced in such a manner as to prevent danger arising to the public. That any dangerous animal should be destroyed, confined or otherwise disposed of. So this happens when there are mad dogs roaming on the street. Municipality has an obligation to clear those animals. But if they don't take, it could take away the life of a small child or some adult person can be mauled. So district magistrate, you don't have to go to High Court for this. Next one, please. There are some more in this. Okay. Not just removal. If something has to be repaired, that has to be done. If something has to be fenced, that has to be done. Right? No order duly made by a magistrate under this section shall be called in question in any civil court. So this is more like a dictator direction, because that district magistrate is authorized to protect the citizens, people within his territory. So to protect and safeguard the rights of public, general public, magistrate can pass orders, and this cannot be challenged in a civil court. That means the person against whom magistrate takes an action, that person has a remedy to go to High Court. Okay, and that's all. Next, please. That's all. I think I took around 45 minutes. So yeah, Priya, Suprajaa, Harini, if you have any questions, I didn't prepare myself a Q&A. So my only request to all three of you is, you know, think. Please think. I cannot say think with respect to postal department. Think what are the problems faced by the railways. I cannot tell you that like that, right? Whatever you see as wrong, right? How can one say what is wrong? For example, I am traveling on my two-wheeler on the footpath. Am I right or wrong?
You're wrong.
Hello?
You're wrong.
Wrong. Why?
So footpath is not for two-wheelers, right?
How do you know footpath is not right for bikes?
That's for people to walk.
If you go to this point of view to the court, you will be dismissed. You have to say, as per Motor Vehicle Act, road is for this purpose, bike travel, footpath is for pedestrians. Likewise, you have to talk to court. Okay, in our gathering, it is fine. So if you know what is correct, you will easily know what is wrong. If I know what is good, I will be easily identifying bad. Right? So I request all three of you, please come up with a list. The list can be 3 or 5 or list can be 1,000. I don't care. Come up with ideas. Don't think any idea is silly, stupid, idiotic. Don't think like that. Because an idea takes the shape of a small baby only. Nobody knows what the baby will do after growing. So this idea we will discuss in the group. Priya will drive that initiative also. We will have a discussion. Once we discuss that idea, we will see different views. Someone supporting it, someone not supporting it, someone saying there is a danger in doing that, there is no use in doing it. So let us gather all the opinions around that idea and see if that idea can be developed into a petition. Because this journey from an idea to the petition, it takes some time, lot of effort, research work, studying work, reading, maybe talking to other advocates, talking to general public. I don't know, right? So a lot of work is there. And as a closure, if you begin coming up with an ideas now, it will take many weeks and months to create that petition. So if you want to file a petition in December this year, I think I have to start researching right now for a petition to be filed in December. That is how we have to work. Okay. And this is first session on technical side that I started. Maybe 1 or 2 days later, I will take up another slide show like this, a slide deck like this, wherein I want to talk about maybe 3 or 5 ideas that I have listed myself, right? They are pertaining to different subjects. One is my favorite, my number one priority at this point in time is dowry related subject. And then there is something else I thought. Priya, can you go to slide number 6, please? Yeah, if you see the underlined portion, I want that to happen in India. And how did I get that idea? I was researching something else and I found a senior advocate from Tamil Nadu, Chennai. He was giving a speech to a, I think, college or somewhere, wherein he said, Parliament has a power to pass a law and give the rights the Supreme Court has to that court to pass writs. What happens then? A citizen like me sitting in Vijayawada, I don't have to go to AP High Court or Supreme Court. I can go to the district judge in Vijayawada, metropolitan judge in Bengaluru. Why not? Why should I waste my time, energy, and advocate fees by going to High Court and Supreme Court? I can go to district judge, right? So this will save money and time and efforts to the litigant. Advocates will be able to fight for the clients at district itself. They don't have to go to High Court. And they can do this service at a low fees because it is not High Court. You don't have to charge too much, right? Even judges, Which two courts in India have a power to give writs? Supreme Court and High Court. Now that power, if it is given to district judges also, there will be so many more judges who are working on writ jurisdiction. For your information, I'll give one statistic and end this session. There are nearly 14 lakh writ petitions pending in all courts, Supreme Court and High Courts in India as on today. 14 lakh writ petitions. And how many judges are there in all High Courts and Supreme Court? Hardly 3,000, I think 7,000 judges. 7,000 judges have to dispose 14 lakh petitions. 7,000 versus 14 lakh. When will they dispose all those? And until they dispose all the 14 lakh petitions, nobody will file writ petition in entire India? No, people will keep filing. So give power to district judges also to dispose of writ petitions. How many district judges are there? At least 15,000 to 20,000 district judges. Just imagine 7,000 judges plus 20,000, 27,000 judges. Right? So this small sentence that I underlined can be turned into a public interest litigation, but I am following the procedure that I defined for myself. First, I have to send a representation to the union government because they are the part of parliament. And once they don't respond to me, then I will go to the High Court. Okay. So similarly, if you can find problems, improvements, everything you see, everything you hear, there is an idea for public interest litigation. You may not get money out of this litigation, but then you get respect of the community, respect among your colleagues, advocates, and general public will love you. That is what public interest litigation may get you. Definitely not money. So thank you so much for your time, friends. Okay, I'm done.
Yeah, thank you, Sandeep. Thanks, Suprajaa. Thank you, Harini. I think by next session, can you come up with a list of ideas, and then we can post it in the group. So I'll send the next invite after discussing with Sandeep. Thank you so much.
Thank you. Thanks a lot. Thank you, Sandeep.
Thank you, everyone. Thanks for your time.
Yeah, thank you.
Bye.